As an estate planning law firm, we consider the foundation on which your entire estate plan should be built around is the Revocable Living Trust. However, we've often found that people either don't really understand what exactly a trust is, or they think it's something only rich people do just to hoard money. While wealthy people do utilize living trusts, they are by no means a tool limited just to the wealthy. But that does raise the question, what is a living trust? Hi, I'm attorney Andrew Bethel. Putting it plainly, a trust is a legal entity that holds assets put into it. A very simplified illustration would be to think of the trust as a bucket to hold water for later use. Well, someone needs to supply the water for the bucket. Someone needs to safeguard the bucket, make sure it doesn't spill, leak, or whatnot. And the water in the bucket is being held to benefit someone else. Put out a fire, water some plants, doesn't matter. In essence, a trust is stuff set aside for someone else. With that said, there are a few legalese terms you should know. So the person who puts the water in the bucket, the one who creates the trust, they are the settlor, or sometimes called the trustor. They're the maker of the trust itself. And with that, they have the power to amend and change the trust, as well as the power to revoke it entirely. They can throw out that bucket. Next is the one who's managing or safeguarding that bucket, and they are the trustee. Trustee has various duties in that role. Namely, they serve in a fiduciary capacity to the beneficiaries and thus must act in the best interest of the trust and its beneficiaries. The trustee, they have to protect the trust assets, they have to keep an accounting, they have to communicate to the beneficiaries, they have to treat those beneficiaries equally, and they have to make the trust assets productive, meaning that the assets need to be responsibly invested and cannot remain idle. Finally, we have the beneficiaries, the one for whose benefit the water bucket trust was created and used for. Beneficiaries have rights due to their position as such, and that includes a right to reasonable updates, information upon a reasonable request, or an accounting at certain intervals. However, a beneficiary's primary role is to be the watchdog of the trustee, to make sure the trustee is acting in what's called due care, and the beneficiary or beneficiaries are the ones with standing to sue the trustee for mismanagement. At this point, you might be thinking that setting up a trust and putting your assets into it means you lose control over everything you've worked so hard to build in the first place, right? Well, no. There is nothing that says the settlor, trustee, and beneficiary of a typical living trust have to be different people. They can all be different people, they can all be the same person, or some combination. However, the way living trusts are often set up is you set up the trust as the settlor, you fund the trust by transferring assets into it, usually just titling property under the name of the trust rather than your name as an individual. Next, you manage the trust assets as you see fit, and you enjoy the assets, as in you benefit from them. Your other beneficiaries, like your children, a charity, or whatever you pick, while they may be listed as a beneficiary in your trust distribution, they can really be thought of more as potential or contingent beneficiaries. As one, you can always change or completely revoke the trust, and two, the condition for them being a beneficiary with the rights that accompany that role, it hasn't materialized yet. That's usually your death. At that point, a new trustee, known as the successor trustee, steps into the manager role, and they manage the trust assets and follow the trust's instructions. So they gather the trust assets, they pay any last bills and expenses, and they distribute the trust estate to the beneficiaries according to the terms you specified. And that successor trustee is going to be someone you picked when creating the trust in the first place. Hopefully after all that, you realize that a revocable living trust seamlessly integrates itself into your estate, that is the way you run your life, such that it doesn't take any special extra outside work aside from setting up the trust in the first place. The assets are still yours, you follow your taxes as normal, and your tax bracket doesn't change. The only real change in how you manage your affairs is that you'll title assets into the name of the trust rather than leaving them in your name as an individual or a couple if you're married. Finally, with just how little a revocable living trust changes your day-to-day management of your affairs, your next question might be, well, what's the point of the trust then? Well, there are quite a few reasons. First, it avoids probate. Next, it keeps matters private. Additionally, the trust makes it easier for others to step in at incapacity. Trusts are often used when qualifying for long-term care coverage, such as through Medi-Cal. And finally, trusts can be customized to tackle non-standard distributions or tough situations, such as special needs children, substance abuse, or even blended families. Now, we'll cover those situations in their own video, but for now, I want to stress the main reason, and that's avoiding probate. A revocable living trust avoids probate by essentially not dying with you. When you pass away with a properly funded trust, as far as the government is concerned, you passed away with basically nothing in your estate. Remember, the trust is holding that water, that is your assets, in the bucket on your behalf, so your heirs aren't shackled with cleaning up the water that's spilled everywhere because you never put it in a bucket before passing away. No trust means your heirs are stuck in probate. Now, we've extensively covered probate in some of our other videos, but in essence, probate is the public court process of passing on your estate to your heirs, and it accounts for everything from furniture to real estate. Probate court is expensive and easily costs over $10,000 at minimum because legally required attorney fees, executor or manager fees, ever-increasing court filing fees, and other miscellaneous fees or requirements like for appraisals, public newspaper notices, or bonds. Additionally, the phrases probate court, quick turnaround, and smooth process are things virtually never uttered in the same sentence, aside from attorneys telling you not to expect those things to happen together. Despite revocable living trusts being prevalent for many years at this point, the sheer number of people who pass away means probate courts are densely packed with heavy caseloads and full calendars. This means the dates are often very precious, and any delay or continuances all but guarantee you've added another 2 to 3 months to the timeline. Due to this, it's not uncommon for probate cases to take at least 9 to 12 months to finish, and that's for an easy estate. For context, a trust remains private and can often be wrapped up within 6 months, depending on how proactive that successor trustee really is. Thank you for watching. Be sure to like, comment, and subscribe, and ring the little bell to stay up to date. Otherwise, we'll see you again soon.